Attorney Hull. Did you have any concerns about the document that I sent you? I have been.
I was just now reading it because for some reason I was looking at your other email chain and I was not able to. This is a different email chain with the court, so I probably not.
Thank you.
Yes, that's looks good to me.
Okay, thank you.
All right. This matter was set for 1:15, and my apologies. I blocked out the entire afternoon for a trial on this matter. The title of the case is Riverside Estates versus Amanda Boyer. Riverside Estates is the name of a small trailer park campsite place on Withers Road here in St. Joe County. They are represented by attorney Dana Hull from the Swistack Levine law firm. The defendant, Amanda Boyer, is present and she's represented by Megan Bauer. We had several previous hearings in this matter, dating back to June. I thought we were close to resolving the matter in August, but we weren't. I set the matter for hearing for August 13th. It wasn't resolved. There was an escrow order in place. I believe the defendant has paid. I wasn't clear. Escrow for, I think, June and July, but I don't believe escrow was paid for August. Anyway, the matter was set for a hearing today. This is filed as a non-payment of rent case. And defendant, which is a whole issue, whether you can file a demand for non-payment of rent case in a mobile home case, but I think this is lot and trailer. So the defendant raised a number of habitability issues, and I'm concerned about some of those at this park. Some photographs and other documents were presented. An exhibit list was presented today, but I'm advised by Attorney Bauer that a settlement has been reached. I gave Ms. Hull permission to appear by Zoom. And Ms. Bauer is here live with her client. So Ms. Bauer, what's the status here?
Good afternoon. Thank you, Your Honor. You are correct that there are 2 months paid into escrow. Ms. Boyer was prepared to pay the third month today, but we have, as you've indicated, reached resolution on the matter in the case. At this time, the parties have agreed to a conditional dismissal of the case on the terms that Ms. Boyer and her family will return the keys and vacate the premises on or before October 5th of 2025. And the amount of money in escrow currently should be released to the plaintiff. And the release of that escrow will satisfy the outstanding, account between the parties through the last day of occupancy, whether that be October 5th or earlier. Ms. Boyer does not want to stay there any longer than necessary in light of the positive bacteriological tests at with the water and the other issues that you referenced on the record. The parties have agreed that the security deposit's not contemplated by this agreement, so it'll be handled in the ordinary course. Ms. Boyer will follow the security deposit law or the Landlord-Tenant Relationships Act with regard to her forwarding address. And the case is to be dismissed now on the condition that Ms. Boyer and her family follow the terms of this agreement. And as long as they remain vacated from the premises, the case will stay dismissed. However, if the tenants have not vacated on or before the 5th, then On or after Monday, October 6th, the plaintiff is free to file an affidavit of default, request reinstatement of the case, file an affidavit of default, and ask the court to enter an immediate judgment of possession and sheriff's order to be immediately issued to Sergeant Morse or the sheriff of plaintiff's choosing. However, if the court is not satisfied that Ms. Boyer has defaulted on the terms of the agreement, then the case is to remain dismissed.
Ms. Hall, do you hear everything that Ms. Bauer said? And you agree with that? If she vacates by October 5th, case will be dismissed. Effective today or tomorrow, the escrow funds will be remitted to the plaintiff, and that will resolve the case. I couldn't hear you.
I said, yes, that's our agreement.
All right, thank you. Ms. Boyer, do you understand that if you don't vacate, you'd be subject to immediate eviction?
Yes.
Now, I went out there this morning. Actually, I did 3 things in that neighborhood. I also viewed a garage that's being built without a permit and another problem property in that same vicinity. So I killed 3 birds with 1 stone. There were 5 cars at your lot. Are you in lot 22?
Mm-hmm.
It's the last trailer on the end. Yeah, there were a bunch of cars parked there this morning at about 10 o'clock, 4 or 5. And Ms. Hall, I had invited one of your colleagues to come view this property. I think you'd have a new perspective on it. I suspect every one of those taps is full of E. coli bacteria. That park has been there as long as I've been alive. Everybody is flushing their toilet out of the same groundwater where the wells are. As far as I could tell, there's no sewage treatment facility. There's a couple of outhouse kind of bathhouse things. Anyway, so I think there's some serious issues with the sanitation there. But by this agreement, we don't join that issue. You simply agree to vacate.
Yes.
Now, frankly, you should have vacated a long time ago. The sooner you get out of there, the better off for you. But I had this situation, I mentioned this more than once here on the record, of another place that I call the health department. And they were reluctant to go condemn it and make everybody that was there homeless. It was a larger park than this. But I suspect the problem you had is with others. But as I said, there were how many people are living there?
Me and my 3 kids. So
do you know who all the other cars were?
And I'm the only one that's got the vehicle there. There's a burgundy car there, but there's a green van behind me. That's where other people live. And maybe across the street at a yellow house, but
this is as you go around the curve at the bottom of the ravine there?
it's not at the bottom. It's like when you pull straight in, you go straight back and you can turn and then
Yes.
go down. Yeah.
It's
not
lot 22, the last trailer in
Yep.
the row.
on the right.
Yeah, there were 4 or 5 trailers parked there, or cars parked there. So maybe they went to the adjoining lot or something.
Maybe, I don't know.
There was some sort of dilapidated structure in the back, like a shed or something.
It did look crowded when I was there, Judge.
But I think it's just where it's so small. There's like no space. You got a truck here, a van here, my vehicle here, one in the driveway, and then
Well, you're gonna leave the property.
yes.
I was told there was 2 $400 payments, but I don't think that's right. Rent is $9.95 per month. I think you made 2 installment payments of $9.95.
That's correct, Judge. I don't have the receipts printed, but Ms. Boyer did send me
Are we talking? Yeah.
the escrow, yeah. It was in multiple portions, but I think that has to do with money orders being limited.
All right.
Yeah.
All right, does anybody have the order, or are you gonna present it to me?
I have an order right here, Judge.
May I see it?
Absolutely. May I indicate one additional thing for the record, Judge?
Yes,
There is an additional named defendant, Mr. Alan Preschauer.
yes.
I told him that because we had reached settlement and he was represented, and to avoid losing his job, that it was better that he attend his work again because he was represented. So he has consented to the terms of the settlement as
All right,
well.
it's Amanda Boyer and all occupants,
Yeah.
and this
I have
order
the-
says
That's
Amanda Boyer et al. All right, it's signed by
Okay.
uh, Megan Bauer, Amanda Boyer, on the record for Alan Freshour, and Miss Hull, formerly, you're now Dana Holm.
Depends on who you ask, I guess. My main name is Holm. I'm going back to that. The state bar hasn't changed it yet, so it's,
I'll call you by what you prefer, but I've known you as Dana Hall. And we have your consent on the record to this agreement?
yes.
All right, you have a little more than a month to vacate, which I certainly encourage you to do.
Judge, I'll indicate that Ms. Boyer has been diligently working and has something in the works.
Good. All right, Ms. Hull, thank you. And I'm glad I didn't drag you all the way down here for this settlement, but I know you and your firm's been working on settling this. But you've heard my concerns about this park. This issue is gonna come up again.
It is, Your Honor. I've never dealt with this part in particular. However, I haven't seen the well water gets tested weekly and there hasn't been, to my knowledge, a bad test coming back, except I think there was one in July and then they tested again the next day and it was fine. So if anybody has one, I'd
All right.
like to
Maybe there's more to it. But, okay. Anyway, this case is resolved. We don't have to join that issue. I'll give you the file to the bailiff. I'll take you get a copy of the order of conditional dismissal. One way or the other, you're gonna be out of there by this October the 6th. And that's good for everybody concerned. All right, thank you.
Thank you.
Okay. Okay, I guess I'm all set then. Thank you.
Yes, sir, thank you.
Thank you, Attorney Hall.
Thanks.
Uh,
I was just gonna say the same thing.
Paul, this goes with that. All right, we're gonna return to a bond. Stop the record. The live feed is still on. All right, defendant. Mr. Faison, what do we know about the test?
I was told that it was all negatives. It did look diluted though, but the tests all showed up negative, so.
All right, I guess we'll accept that. Well, that's a plus. So in light of that, Mr. Faison, what's your recommendation?
Well, Your Honor, I had noticed several conversations I had with Ms. Bond about the landmark, and she left there to go to the spa, and then I got some correspondence from or spoke to on the phone, the person from the counselor from spa, who said that she wanted to leave there because she wanted to be closer to her children. I don't believe at all that she was confused about the program. It was very clear with the paperwork that I would have given her from the probation. She did just leave regardless of what happened. She knew she was on probation. She just left. And then when she got bonded out, she didn't contact me. When she was talking about how she got arrested in Cass as a PO, I hear, well, they didn't have any probable cause. And they wanted clean.
Yeah, she wasn't very repentant or
Yes,
sorry about
and,
it.
and I heard a few excuses coming out here, so it makes me concerned since we never had any tests. And unfortunately, I have 5 almost identical situations with females with a meth that went to facilities and then just said, well, I'm doing great for the last year, 2 years, 4 years. And all we have is their word. She does look better than her photos, her past photos, so I'll give her that. And it was negative today, and I'll give her that. But the fact of the matter is she had a probation. It was specified that she was to go there. And this started off as a felony, and it was enough to where the judge held 81 days over her head. My recommendation, which obviously is up to the court to decide on this, is just to do the 81 because I believe that's what she would have gotten. And I have not seen anything that's contrary other than the 21-day program she did at Landmark. That could be taken and, weighed against the 81 days. But other than that, she just blew off probation.
All right, Mr. George, what would you like me to know?
Well, first off, Your Honor, I'm going to leave any discussion about the treatment to Ms. Bond. She has some information she wants to give the court to that. But I had a case that was similar to this about a month ago, and I think that what Dan said is right. I mean, she looks better, she presents better. She's here 20 minutes early for her hearing, which isn't nothing. She reports that she has a job. She gave me her boss's name and phone number, which is, I think something where if the court wanted to confirm that she's doing that work, she gave me a phone number to do that. She seems like she's proud of that work. And she just got her 9-year-old son back in her care. So in a lot of ways, I think the goal of the probation is to see what the end result of Kayla would be if given this course of treatment. Now, obviously, there were orders in place. She didn't follow them. She acknowledges that. She kind of fell off the map for a bit. I'm not aware, and the court and Mr. Frazine would have more access to this information than I would, of any new criminal charges in between now and then. I know there was the stop that was concerning, and there are some flags. I can't deny that, but I think she's overall in a better place now than she was before. That doesn't negate that she, didn't follow the terms of this probation, but I think it is something that the court can take into consideration. I don't know if she was bonded out right on the 20th when she got over here, but she would have 16 days to her credit. I'm just concerned that, if we were to just do a flat jail sentence of the deferred time, some of those gains that she has made would be lost. And, I don't want that for her. And, I know that she doesn't want that for herself. So we would just ask the court to take that into consideration. If the court does want additional jail time, I think we could, schedule that so that she can let her employer know and be able to maintain that employment while making sure that there are accommodations for her son to be taken care of. Thank you.
All right, Ms. Bond, you did Landmark, which was, I think, 21 days. And you were going to do the spa, and that was only there for 3 days, and then we lost track of you.
I never checked into the spa. I was
Okay.
only okay, this is what happened. I know what he's talking about now. The first 3 days that I was at Landmark Praxis, which is the same thing, same name. The first 3 days I was going to walk out the doors. I remember this all too clearly. one of the Pez's had called Dan and put him on the phone with me on speakerphone because I was ready to walk out of there. And he told me that if I didn't turn back around, I'd have 1 year in jail. So I said, okay. So I turned back around and I finished out my 23 days at Landmark Praxis. I was never checked into the spa ever. That was a whole year program. And I ended up finding Landmark in place of
Right.
the spa.
Now, this case was a 22 case. You had a meth charge in Cass County in 23. What happened to that case?
That I'm not sure of. When I just got picked up, there was nothing about it. I have no idea.
He had a prelim scheduled in a methamphetamine case in Cass County. At about the same time you were gonna go to treatment.
And they knew I was going to treatment because Attorney Hogue was speaking with my navigator and stuff also.
Well, and then you just got arrested in Cass County.
Mhm.
Would you ask Jenny to run a new criminal history